When a disagreement between neighbors breaks out, the tension can quickly turn a peaceful street into a battlefield. And when a conflict escalates, whether it's an encroaching fence or a dispute over property lines, the immediate emotional instinct is to call in an authority to force a resolution. But when you live in a community association, homeowners often make a critical mistake. They treat their HOA board like a private police force, or worse, they expect actual law enforcement to care about the neighborhood bylaws. Neither party can do the other's job. Your community is governed by two entirely distinct authorities. The HOA strictly enforces contractual covenants, like your architectural rules. The police enforce criminal law and local ordinances. This comparison table shows exactly where the lines are drawn. Misdiagnosing which side of this table your dispute falls on guarantees your complaint will be dismissed, leaving the harassment entirely unaddressed.
Pushing the wrong jurisdiction also has severe financial consequences. In Florida, if a homeowner ignores the legal boundaries and tries to skip mandatory pre-suit mediation to file a lawsuit directly over a covenant dispute, a judge will immediately dismiss the case. Under strict state fee-shifting laws, you will automatically lose the right to recover your attorney's fees, even if you eventually win the broader lawsuit. Accurately defining the jurisdictional boundary of your dispute is the only way to trigger actual enforcement without risking a massive personal financial loss. This flowchart evaluates neighbor incidents step by step. The first branch, police jurisdiction, handles public safety and local ordinances. If a neighbor throws a massive party at 2 a.m., threatens your safety, or cuts down your tree, the behavior crosses into criminal activity. Calling the police in these scenarios yields immediate, on-the-spot legal intervention. Officers can measure decibels, issue citations, or make arrests. The trade-off, however, is that this permanently escalates your relationship with that neighbor into criminal territory. Now, contrast those severe inputs with an aesthetic complaint. Say your neighbor paints their house hot pink without approval, or parks a car without a community decal on a private, HOA-owned street. If you try to push these issues down the police path, you hit a dead end. The police will absolutely refuse to intervene because they lack the jurisdictional mandate to enforce private contractual bylaws or ticket cars on private property. Law enforcement evaluates disputes exclusively through statutory and criminal definitions. If your grievance is civil, contractual, or aesthetic, the police will completely ignore it. Moving to the middle branch, we have HOA jurisdiction. Florida's House Bill 1203 intentionally stripped boards of their law enforcement-style powers. If a homeowner demands fines for a commercial plumbing van parked in a driveway or a messy hidden garden, the HOA hits a wall. The homeowner must accept these visual annoyances without any HOA intervention. The state legislature legally capped the association's enforcement powers over personal driveways and unexposed backyards to protect private property rights. Then there are the petty, non-discriminatory squabbles. A common input is one neighbor complaining that another neighbor's tree drops leaves into their pristine swimming pool.
Florida law provides the board with a powerful shield called the business judgment rule. It protects boards who formally review this type of private civil dispute, categorize it as a matter strictly between two individuals, and deliberately choose to do nothing. The trade-off of this rule is clear. It successfully shields the board from failure to enforce lawsuits. However, it leaves the aggrieved homeowner completely on their own to fund a private civil action if they insist on getting the matter resolved. The modern HOA is strictly a contract enforcer with a legally limited scope. It is completely unequipped to act as a neighborhood referee. But there is a major legal threshold where the HOA cannot look away. Let's trace the final branch, the federal exception. If a homeowner is targeted by discriminatory harassment based on race, religion, sex, or disability, the board's legal obligations change entirely. Under the Federal Fair Housing Act, the HOA is legally mandated to immediately use its maximum enforcement mechanisms. This means issuing fines, suspending amenity access, or sending attorney cease and desist letters to force the hostile neighbor to stop. In this scenario, the legal burden shifts entirely onto the board. If the management company or board tries to claim the harassment is just a private matter and ignores the complaint, the targeted homeowner can sue the HOA directly in federal court. When the board does have to step in on a severe covenant violation, Florida law introduces a statutory trapdoor. If an HOA demands formal pre-suit mediation and the offending homeowner ignores that demand to rush straight to a judge, the judge will instantly dismiss the case. By skipping mediation, the homeowner triggers a strict fee-shifting penalty, completely losing their right to recover attorney fees, even if they manage to win the broader lawsuit later. Navigating these legal gray areas incorrectly results in one of two disasters. It either exposes the board to massive federal lawsuits, or it bankrupts the homeowner through automatic fee-shifting penalties. Whether dealing with the police or your HOA, both authorities operate exclusively on organized evidence. This checklist shows the paper trail protocol, the 3 specific items you need: a precise time and date log, decibel or video evidence, and a record of written, polite communication. When you submit a highly organized folder containing exactly these 3 pieces of evidence to the correct authority, you force their hand. Compiling this evidence requires a significant amount of upfront administrative effort from the homeowner, but it exponentially increases the probability of definitive intervention by removing all ambiguity from the equation. For the action-seeking homeowner, the directive is clear. Stop weaponizing the HOA for private civil matters. Use the jurisdictional matrix to direct your complaints accurately, and never skip mandatory mediation. For the risk-averse board member, lean heavily on the business judgment rule to avoid acting as a neighborhood referee. But the second a complaint reaches the Fair Housing Act boundary line, aggressively intervene to prevent federal liability. Successfully surviving a neighborhood war relies entirely on 2 things: gathering irrefutable evidence and handing it to the correct legal authority.